terms of the resolution dated 22/8/2023, respond number 2 state issued an advertisement on 10/9/2023 inviting application for 20,000 post of junior teacher schematic through online mode. Then on 15/1/2024, the respond number 2 published the draft merit list of successful candidates that were totally 18,788. The draft merit list was prepared. Process was contemplated. After following that process, 18,788 candidates were successful. That list was prepared. That is a draft select list. Then 2024, some of the unsuccessful candidates was the market. Some four unsuccessful candidates. In fact, at approached this honorable court. The WPC number 978 of 2024 challenging the draft merit list dated 15/1/2024. Then on 16/1/2024, the total 18,788 candidates, including the present appellants, whose name found place in the draft merit list, were called for the document verification on 21/2024 and 21/1/2024 by notification dated 16/1/2004, and out of 18,788 candidates, 16,218 candidates, including the present appellant, were successfully verified on the basis of the selection that draft merit list. Then on 12/3/2024, the Honorable Single Judge, by the impugned judgment dated 12/3/2024, quashed the draft merit list dated 15/1/2024, as well as the district-wise and categorized merit list. Entire merit list has been quashed now. That is the subject matter. The judgment of the Honorable Single Judge is the subject matter challenge. And I have prepared the points because your Lordship wants always what are the real points. These are my very limited points so far I am concerned. I don't know the state and other councils are appearing for other petitioners. First of all, we are not made party. Not a single person, even in the representative capacity, those who are successful and those names found place in the merit list, those names are already verified for the purpose of appointment. They were not made party, not a single person. So first point I have formulated, whether the Honorable Single Judge was at all correct in entertaining and allowing the writ application bearing number so and so, when the writ application suffered from non-joinder of necessary party and not a single successful candidate has been arrayed as a party, even in the representative capacity. The judgment I have given 2-3 Supreme Court judgment and one judgment by a coordinate bench of this honorable court recently, where my Lord Justice Raman was also a party. That Kavita Jana's case, that OPSC's matter, same thing. Then the next point I have formulated, whether one of the candidates, petitioner, who failed to achieve the minimum cut-off marks, thereby excluded from the state-wise merit list and subsequently modified district list, whether the writ application at all maintainable at that best. Whether in that case was, this should have been district-wise instead of state-wise. That is the entire case. Now, due the course of hearing before the Honorable Single Judge, what I found from the records, the state government filed an affidavit specifically saying these 4 candidates, they have neither satisfied the last candidate who have been selected. These 4 candidates have secured less marks, both in category-wise, state-wise, as also district-wise. So, on any circumstances, they could not have got the appointment. Then 3, whether the Honorable Single Judge was at all correct in interpreting clause 8.3 of the advertisement in holding that the preference in the district has to be given priority rather than the merit of a candidate. Now, Your Lordship can look to the judgment. Before I take Your Lordship to the citation, I just, what was the question?
What was there in the advertisement? Whether it was to be district-wise or...
That is at page, Your Lordship, kindly come to page 20. Page 20. That is the advertisement. I'll take Your Lordship to that also. I'll address Your Lordship on that point.
All right.
But before that, I'll take Your Lordship that whether the judgment can at all be sustainable without impeding a single person who was names found place in the successful list, in that merit list. That is my first point. And what was the question? This question was raised before the Honorable Single Judge by the state. Your Lordship, state may come to the impugned judgment at page 253. At page 253, internal page 26 of the judgment. Paragraph 5.3. So far, the Lord Advocate General's contention is concerned. No, 2 I'll come later on in a different point. addressing your lordship at part 5.3, Learned Advocate General contended that since the recruitment in question is to fill up 20,000 posts of junior teacher schematic, and out of 20,000 posts, 9,982 candidates in category 1, 8,806 candidates in category 3 have been selected in different districts from different districts. State candidates so selected will be seriously prejudiced if the state is not permitted to proceed with the selection process. 5.4. With regard to the allegation made by the council for the appearing for the petition in the present writ application and to the submission of the learned council appearing in other batch of writ application, Learned Advocate General contended that since none of the candidates whose names appeared in the impugned draft select list published under Annexure 6 series have been implemented as a party in the writ application, no adverse order can be passed without them being brought to the records. They are brought on records. In support of the aforesaid submission, the Advocate General relied upon the judgment of the Honorable Apex Court in such and such case. Quotation, I am reading just quotation 3-4 line. One more submission, that was the quotation from the judgment reported in 2020-18 SCC page 673, para 34. One more submission raised by the Land Council for the appellant in civil appeal, filed by so-and-so case, needs to be noticed. The submission of the appellant is that respondent number 1 in this writ application number 1270 of 2008 did not include any of the selected candidate out of the list of 832. No selected candidate having been implemented by respondent 1, the High Court erred in issuing direction to modify and review the select list. The direction of the Honorable High Court in paragraph 51 is clearly against the interest of the appellant, who as per the direction shall go out of the select list. The select list having been published on such and such date, much before the date of the respondent filed the application for amendment of the petition for challenging the advertisement number so and so. He ought to have implemented the selected candidate whose names were already published by the MPSC. Respondent number 1, without bringing selected candidates on record, could not have obtained any order adverse to the selected candidate. Then you also kindly come to page 257. 257. Because I don't want you also to kill time. 257. That is, again, the contention of the Land Advocate General has been also recorded by the Honorable Single Judge. Para 5.6, top, page 257, running page 257. Land Advocate General also relied on the decision of this court, which I just was referring to, that Kavita Jana's case where my Lord Justice Raman is a party. Also relied on the decision of this court in the case of Kavita Jana versus so-and-so, decided on 22/12/2023. This court in paragraph so-and-so of the said judgment has held as follows. Just first paragraph, last line. In the present case, the issue of non-gender parties was raised at the earliest, but the same has not been answered. The aforesaid finding was arrived at by the court relying upon the judgment of the Apex Court, as discussed therein, and as such the appellant have also relied upon those judgment in the present proceeding. Therefore, there is no iota of doubt that one single judge ought not to have proceeded without insisting upon impletion of selected candidate as opposite party in the writ application, that is WPC number so and so. Then you also kindly state to that judgment has been quoted in extenso. You also come to page 259, the last of 4 line of that judgment, that Kavita Jana's judgment. That page 259, internal page 32. When the right accrued in favor of the selected candidate have been grossly affected for non-inclusion of their names in the writ application, the writ application suffers from non-gender party. But that judgment I have also brought, that was a case also where a draft merit list was prepared, a provisional merit list was prepared, that was subsequent matter of challenge. Then sir, kindly come to page 274. That is the finding of the Honorable Single Judge. At paragraph 8.7, 274. With regard to the, let's get it. With regard to the stand taken by the Land Advocate General that since the selected candidate whose name found place in the impugned draft result sheet published under Annexure 6 series have not been implemented as a party to the writ application, the writ application is not maintainable. It is the view of this court that the present writ application along with the batch have been filed challenging the draft merit list published by OP number 2 under Annexure 6 series. Since the impugned draft result sheet is a draft, draft list, though it has not been published in terms of the provision of para 8.3, and the final merit list is to be prepared after exhausting the provisions contained in 8.4 and 8.7 of the resolution related to also. This court is of the view that since the list published under Annexure 6 series and the list published district-wise and categorized a draft select list, which is to be finally published only after completion of the process, so provided under 8.7 of the resolution, the candidate whose name appears therein are neither necessary party nor proper party to the proceeding. This court find no substance with regard to the plea raised by the learned Advocate General, and the writ application is not maintainable in absence of the selected candidate having been implemented as a party to the writ application, and decision rendered in case of Kavita Jana is not applicable. Now, Your Worship, kindly look to the judgment. I have three judgment I have brought to Your Worships, and Your Worship, kindly have a glance to that judgment. First judgment I show Your Worships, which has been relied upon in that Kavita Jana's case. That is Odisha Public Service Commission, our state's case, Priyamvada Das case, in which a Supreme Court judgment has been referred to and relied upon. One paragraph, I'll take Your Worship's time, one paragraph. That is paragraph.
Sir, 6 question of praise.
Yes, I'm just. Yes, sir. Your Worship, kindly come to question of the 6. Now, so come to page 10. But sorry, that is internal page 4. Internal page 4. The issue which was framed, Roman 3, whether the case suffered from defect of non-gender party, since, sorry, madam,
Yes.
paragraph 6, page number 4, Roman 3.
Yes.
Whether the case suffers from the defect of non-gender parties, since all successful candidates of OCS preliminary examination 2011 are affected and have not been made parties. Then your state may come to para 24. But para 23 also, again, issue has been framed by the court. In that case, internal page 11, para 23. Upon hearing the parties,
Yes.
upon hearing the party, para 23, upon hearing the parties and on perusing the document, including the SCLCR, the following issue arising for consideration in this case. 1. Whether selected candidate of the preliminary examination were required to be made parties before the Learned Tribunal. Then para 24, 4th line I read. Coming to issue number 1, let us scorn the various averment and prayer made by the OP number 1 in the original application. And paragraph 3 of the original application, opposite part number 1, makes it clear that it challenges the illegal action made in the preliminary examination 2011 by OPSC by adopting a wrong and illegal marking procedures. Then para 25 is the finding. Thus, one thing is clear, that on the ground or another, OP number 1 has averred that the result of the preliminary examination conducted by the petitioner has been vitiated, and accordingly, she prayed for setting aside the result of preliminary examination. As indicated earlier, about 5,823 candidates succeeded in the preliminary examination. As per Rule 12.1 of 91 rules, read with clause 2 of City 2 of 91 rules, it is clear that the candidates qualifying the preliminary examination shall only be called to the commission by the commission to appear in the main examination. Thus, the candidate who qualified in the preliminary examination got right to appear in the main examination. In such background, it's needless to say that the selected 5,823 successful candidates have a right to appear in the main examination as per 1991 rules, which is rule made under Article 39 of the Constitution. Since the select list containing roll number 5,823 successful candidate has been set aside by the Learned Tribunal, it clearly offends their right to sit in the main examination. As per the law laid down by 4-judge bench of the Honorable Supreme Court in the decision in Udit Nayan Singh versus Swanso Supra, it is clear that persons who are going to be directly affected or against whom relief is sought for are necessary parties, and they should be named in the petition. it has also been made clear that parties in whose favor an order or notification has been issued, and when the same order or notification is challenged, the said parties are necessary parties. To the same effect is the judgment of Honorable Court in S.C. Kulwant Singh case, Supra. Even as per the decision in the case of Prasant Ramesh, Swarsu, where result of the civil service main examination was under challenge, the Honorable Supreme Court has held that non-impletion of candidate selected in the civil service main examination was fatal. It may be noted here that even though a candidate selected in the main examination has no right to be appointed at that stage, but has a right to appear in the interview. In all India Supreme SC and Civil Type Employees Association case, Supra, the Honorable Supreme Court has made it clear that the candidate whose name are in there in the provisional selection, that's about it, in the provisional selection, even have interest public right in protecting and defending that select list. A reading of the decision rendered in Southern Holia's case, that Supra, makes it clear that the Honorable Supreme Court was not satisfied with the course of action taken by the High Court in inviting the objection from the selected candidate who had never bothered to be made parties. In this context, the decision of Dr. Mahapatra in Swanso's case is factually distinguishable. Swanso's, let's skip over. Then the next judgment I saw your worship, that's case Siraj judgment. That your worship, paragraph 52, only one paragraph.
This is one thing they could have said, they could have said that. Question.
Your worship, look to this judgment, case Siraj, reported in 2006 Supreme Court, page 2339. Paragraph 52. Paragraph 52, internal page 27. Page 57.
But you made it a line of decisions.
Yes.
That when the policy itself is under challenge, which is to be defended by the state only, cannot be defended by the selected candidate.
My humble submission.
Possibly the implement is not essential. There are lines.
Here the policy has not been challenged. If you also will look to that, they say that so far as the selection procedure adopted by the state authorities, that is not in terms of the policy. That is what they say.
That is not in terms of clause 8.3.
Right, sir.
That is the only.
That is it. But only after participation and only after the draft list was prepared, they have challenged it.
No, rightly. They could not have challenged the publication.
Right. That I don't say.
Because they must have presumed.
Sir, the only question is
that the states have acted in accordance with what was there in the resolution.
Sir, that matter still, we have to argue that matter, that's another part. But so far the implicit of party is concerned, if you have come to the court of law after the draft list was prepared, but the draft list has been prepared, their names could find place, they could not have come. But the draft list has been prepared, after that they have come to the court. Now the question is, whether at least in a representative capacity, all could not have been made parties, at least one or two could have been made a party. That is what the law.
In any case, can now the appellate court should interfere in view of clear provision under the clause 8.3 of the resolution.
That I understood, so but the 8.3 is concerned.
The direction is only to the extent that you prepare district-wise merit list.
Sir, my point is there. Here also look to the written argument which was submitted by the state before the Honorable Single Judge I have given. You also look to that. That is a page. They have written one paragraph also. Now they have made an attempt to prepare a state merit list as well as the district merit list. In either of the two,
We appreciate your submission that in either of the two lists, the appellants could not have succeeded.
right. They are not qualified even if they have not secured the mark which has been secured by a candidate like us, the last person who has been selected. That is page 77.
All right. Then in that case, the state could have simply followed the direction issued by the single judge by preparing district-wise list in terms of clause 8.3.
Also, far as we are concerned, the whole problem is now the ones that will be the judgment of the Honorable Single Judge is implemented, so for the casting of the list of the recasted, then we'll be nowhere and we'll be affected. We are adversely affected.
You may be affected, but can you make a submission? Can you make a submission against clause 8.3?
Sir, I am not. I have not made any attempt to make a submission against clause 8.3. I'll show that. But my first point before your lordship is, my submission is that implication of parties, because that is very fatal. Even the Honorable Supreme Court has said.
Suppose we set aside the order.
Right, sir. What argument I can advance? That your lordship may put the question. Yes, sir.
What directions? You oppose the stipulations in the resolution.
No,
Like
I cannot. I must go by the.
Would your lordship then permit me? Because I have filed an appeal also. Kindly see, my lord. Kindly see page 5.2 of the judgment. I'll refer to the page my lord friend is referring to. Page 5.2 of the judgment. Internal page 26, running page 253.
Yes.
But I had argued that the petitioner's names do not find in the draft merit list. Now let me tell you lordship the context of this. There were 20,000 posts. Now there were 85,475 candidates, out of which, my lord, 18,788. May I tell you lordships again? I'm sorry. Please. There were 85,475 candidates for 20,000 posts. Now 18,788 called for document verification. And then, my lord, total number of people who appeared were 16,217. Now, post document verification after the draft list, today we are at 15,815. Today, if we have a 15,815. The petitioner's name did not find place in that 1627. So we had submitted before the learned single judge that in any case they are not qualified because they are not there in the draft list. So therefore they have no locus. Whether it will be 8.3, whichever way, they have no locus. The single judge, my lord, with great respect, did not address that. That is one point. Now on 8.3, let me straight away come to 8.3 minutes. And that your lordships will find in this writ petition. Let us see, my lord, that is, if your lordships kindly see, my lord, the resolution is at page.
We are there at 20.
Lordships have it, my lord.
8.3.
Your lordship may see, my lord, before your lordship sees 8.3, kindly see, my lord, there is a clause 3 which says advertisement. My lords have it.
Yes.
So OSEPA on behalf of the school and mass education will publish an advertisement in a widely circulated ODI English daily newspapers inviting online applications for intending application for engagement as so and so. Now, my lord, kindly see 8.1. My lord, what has been missed out is really 8.2.
Yes.
My lords have 8.1, my lord. Yes. Selection procedure. Publication of master list. After expiry of the last date of submission of online application forms, list of candidates for each category with respect to their first preference districts as submitted by them at the time of submission of application form will be published in OSEPA website. Information on subsequent preference districts of each candidate will also be available in OSEPA website. Now, my lord, if your lordships have that application which an applicant makes, he gives a preference of 30 districts. So it is not as if one applicant is saying, I am only giving Baleswar. He gives 30 options. 30 options. Now let us see what is 8.2.
In the order of preference.
He gives. I am grateful. But he knows that he will be fitted into one of those 30s. That's the point. When he is giving 30, he knows he will be fitted into one of those 30.
So is this your submission?
Yes, sir.
The list which was prepared, that was under 8.1.
The list was
stage had not reached. No, this is not your submission.
Now comes 8.2. No, that is not my submission. 8.2 says an online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement, to be published before the recruitment. My humble submission to your lordship is following. This online computer test is a test to determine your merit. And my lords, for determining the merit of the applicants, the single judge says, my lord, the Honorable Single Judge A does not refer to 8.2. B, he says that merit has to take a back seat, preference of district has to take a front seat. That's the short point. May I say it again? 8.2 was inserted to hold a computer-based test amongst the applicants to determine their merit. 8.3, if your lordships read 8.3 along with 8.2, the inescapable conclusion is that merit has a very important role to play in selection of teachers. But what are we doing ultimately? We are selecting teachers to teach students. And if your lordship sees, my lord,
No, how do you say that? This is the finding of Lord Single Judge.
but now, kindly see, the three lordships have read three.
So whatever merit list was prepared
I'm grateful.
by you
Yes.
was on the basis of this 8.2.
8.2. But there are two submissions. 8.2 will select a candidate. 8.3 will say, I will allot you this place. And you have given me a list of 30 in your application. Now, kindly see, my lord, how does the learned single judge deal with this?
No, but did you prepare a
Yes.
draft merit list?
Let me show it to your lordship straight away. Okay.
The document is to the district council.
The first one. Kindly see, my lord. Then please let me see the first one. Now, my lord, before your lordships come to the list, kindly see page 38 of that brief my lord friend was replying.
Yes.
My lord, this list has not been challenged and they have appeared pursuant to this list in the examination. With reference to certain media reports regarding the recruitment of junior teachers, schematic 1 and 2, it is to inform you that so-and-so has been entered into an MOU with Odisha school. You may skip all that. Let me read it. The CBT was conducted in accordance with the requirement of so-and-so. The resolution provides guidelines for engagement of junior teacher schematic, including application, submission model, eligibility age, reservation list, certain criteria of selection process, methodology of finalizing the merit list. Response query management was done and all objections were addressed. After conducting the computer-based test, EDCIL prepared the results as per the guideline provided in the resolution dated so-and-so to the authorized designated officer of OSEPA. Now kindly see, my lords, kindly turn to the next page. That is the list. That is the list that was prepared at the first instance. Now if my lordships will kindly see, my lords, kindly look at serial number 1835. Extreme left. My lords have it.
1835.
Serial number, page 39.
Page 39.
Just after that page.
First number.
Yes.
This is an abstract. Now, kindly see, minutes. The person's name is, the roll number is there, application number is there. If your lordship sees serial number, then application number.
Yes.
Then kindly see below roll number. Then kindly see junior schematic category 1, science, Yojan. Now, my lord, what your lordships are seeing is the merit list of the various candidates. And once the merit list is prepared, then whoever is fitting into which district it has given, the submission to your lordship is merit has been given preference in preparing this list. Let us say, my lord, I prepare a merit list of first 100. So I now pick up who are the first 100 candidates. And then I try to fit in their district preferences accordingly. What the learned single judge says, my lord, with great respect, that you first give them the district they want. And I will show that to your lordships. Merit cannot prevail over the district preference. Now that is the short point which your lordships have to consider, my lords. Kindly see, my lord, what is the finding of the learned single judge. Okay. Now, my lord, if your lordships kindly straight away comes to my lords, the finding, okay,
8.8.
page 8.8, my lord, lordship may see first, my lord, paragraph, page 5, the internal page 15. My lord, 1 second, my lord. Your lordship don't mind.
Submission.
Yeah. Then would your lordship straight away come to minutes, para 8.8, internal page 48, page 275. Page 275.
Yes.
Since this court finds that the draft merit list published under Annexure 6 and or consequential district and category wise list by segregating the names of each 30 districts so produced in a seal cover before court have not been prepared in terms of the provisions contained in para 8.3, the resolution placing reliance on the decisions of so and so I cited this court is inclined to interfere with the draft result sheet as well as the district and category wise list for each of the districts, segregating the names so produced before this court in a sealed cover. My lord, the next paragraph. The stand taken by so and so that the merit list is the sole criterion. But this is the argument that merit is the sole criterion for selection of teachers and that has been followed is not acceptable as it runs contrary to the provisions contained in para 3 of the resolution. Taking into account the submissions of so and so, the list of successful candidates have been prepared. Taking into account their performance and merit, it can be inferred that the stipulation contained in 8.3 of the resolution has not been followed. Since the provisions of 8.3 is very specific, that selection of candidates only basing on their merit, irrespective of their district, of their preference, given for a particular district is not sustainable in the eye of law. This court accordingly is inclined to quash the draft list published under Annexure 6 and so also the district and category list published so and so before just produced before this court. While quashing the list, this court directs the OP number 3, now this is important, to prepare district-wise, category-wise draft merit list in terms of the provisions contained in 8.3 of the resolution dated so and so. After such publication, the district-wise category shall proceed with selection. So therefore, millards, what the learned single judge says is that you forget your 8.2 CBT exam, you forget your merit list, give them as per district preference, namely, irrespective of what mark he has secured in the CBDT list, if he has given Bhadrak as a preference, tabulate all Bhadrak. This tabulation on the basis of their merit is not in conformity with 8.3 and without saying that why, then what was the basis, what was the reason for 8.2? There was no necessity to have a CBDT test, because everybody will be given as per. So in other words, I will now select teachers who are less meritorious and give them the district preference and appoint them, and leave out teachers who are more meritorious. Just 4 lines of a judgment of the Supreme Court, because where is my copy? Where's my mark copy? Just keep it. Did a rage. This is the one. My lords, may kindly see paragraph 2 minutes.
Yes.
This is Anmol Thakur, Kumar Tiwari. This was also cited.
Yes.
This was also cited minutes.
Yes.
A high-level committee was constituted by the state government to examine the irregularities in the selection process. The report was submitted by the DIG police personnel, state of Jharkhand, in which it was found that select list was prepared wrongly by ignoring the merit of candidates and giving them undue preferences given by them. Your Lordship, may straight away come to para 12 minutes. Just 4 lines. This is at page 428. My lords, have it minutes.
Yes.
Para 12. The second issue relates to the claim of the interveners in the writ petitions for appointment. There is no doubt that selections to public employment should be on the basis of merit. Appointment of persons with lesser merit, ignoring those who have secured more marks, would be in violation of Article 14 and 16 of the Constitution. I rest my case there. The sufficient, your Lordship, is that 8.2 read with 8.3, read with Article 14, read with Article 16 is the real answer. The learned single judge says, my lords, that you ignore 8.2, forget merit, only go by 8.3, even though that's 8.3, my lords, go only by 8.3. I am quashing your select list, which is based on merits. Now you give them as per the district preferences. Net, people who did not even qualify, like the petitioners, but they were not in that list, or people who are down below, will now get in. And people who are more meritorious, they will be left out. In short, that is our case. And today, if I have to continue with this process, I will be appointing about 12,000 candidates roughly. But the point is, my lord, merit is going to be compromised.
No, but on conjoint reading of 8.2, 8.3,
Yes.
8.4,
Correct, minutes.
it is apparent that you have to prepare a merit list on the basis of
There is no difficulty there.
8.2.
Well, there's no difficulty.
That cannot be
Well,
compromised.
let me answer that question, subject to your lordship's kind consideration. Is this: I have shown your lordships a master list. Now that master list, when this question was posed to me, I told the learned single judge, and I did file without a district-wise list. But what the learned single judge has said is that this is also wrong, because you have gone by the, suppose we are Bhadrak. Let us take for example Bhadrak. I go by the candidates on the basis
No,
of
that would have been a situation
Yes.
had the selection process been district-wise.
Yes, I'm grateful.
The matter would have been different.
I'm grateful. You answer my question.
In fact, as per the resolution,
Yes, sir.
you had gone for, say, competitive examination.
I'm grateful.
In competitive tests.
I'm grateful.
To have a merit list on the basis of the vacancies which you have.
I'm grateful.
And then you are required to prepare a merit list district-wise, of
Right.
course, keeping in mind their
Preferences.
So, that was all.
So now what did I do? Your lordship saw that page just now, which my learned friend showed that page. Kindly see, Lord, kindly look at page 39 again, Lord.
give their preferences.
My lord. And 30 is what they gave. Oh, wait, is it?
The briefs are so voluminous. Lordship is saying, this applicant gives. I am sorry, my Lord Justice Ramanda. So they give 30 preferences. Right? Yes. Right. So they had given preferences at the time of filing of the applications. I am grateful. And based on their preferences, you prepared a merit list. Not based on their preferences, you prepared a merit list.
I'm grateful.
And you allotted a particular district based on the preferences.
I'm grateful.
Or the candidates already selected might have a grievance that I have not been allotted a proper district.
No one has come.
Therefore, a person may claim, I ought to have been given
Yes.
a puri instead of.
I'm grateful.
Alright.
I'm grateful.
So this can be this thing, but if you prepare a merit, even if you prepare a merit list,
Yes.
district wise,
Yes.
a candidate may say that my preference was this, my first preference was this, I had better merit position, still someone of less merit has been given.
Correct. You will be absolutely.
These circumstances can emerge.
Can emerge, no difficulty. Because he knows when he is applying that I will be considered one of those 30 districts. That is why he is giving 30. Now kindly come to page 39. What has fallen from your lordship? What is exactly what page 39 is? I prepare a merit list. I give them allocation. One of the merit list persons can come and say that, look, I could have got Puri, you have given me Deccan.
And that is, therefore it is draft.
Therefore it is draft. And no one who is qualified, who is a part of the merit list, is before your lordships complaining this. But I called out to what your lordship saying. But if your lordships hold,
As the learned single judge has said, that district-wide preference will prevail over merit, I have no case. I have no case. But if 8.2 has to be given some meaning, and pursuant to 8.2, one test has been held, and based on the mark a merit list has been prepared, and then districts are filled up, and somebody who has qualified, who is in the merit list is complaining, would be a question where lordship may consider. Here,
Why this district-wise list was placed in seal cover?
because my learned single judge said that this is not a district-wise list. So what we did, we broke this list into districts. For example, if your lordship sees page 39, just as an illustration, suppose there are 5 Mayurbhanjas. You put all Mayurbhanj in one. You put. But he said, no, this is not good enough. Because you have prepared this list, certificate. You have prepared this list on the basis of merit. So merit could not have been because 8.3 says it is district preference. So everybody, you first take out the district preferences, irrespective of the merit. Suppose Baleswar, 20 people have applied, fill all 15 in Baleswar first. In other words, my lords, give a go by to 8.2 as the Lordship said, my lord, Supreme Court now says 14 and 16 says that merit is a very relevant criteria.
Who is appearing for the other side?
In fact, to add to this, my lord, the Lordship says,
No, someone is appearing for the other side.
yes.
I have the instruction I did not get, and I have the repetition I have said. I have not filed power, madam. The
File it.
clients, they both person, they
My lord, your Lordship, my lord, may I submit something?
I have to submit, madam.
My lord, may I make a small submission?
Just a minute. What we intend to do is, you are 4 persons.